I'm sorry the chairman's not here, so I can tell him how important this hearing is. This may be one of the most important hearings we've had in the United States Congress in a long, long time. People forget the fact that we have a duty, a constitutional obligation as the Congress to do investigations and oversight. And what this OLC opinion does is it undermines the oversight that Congress has under the Constitution. And I don't know why the Attorney General, General Lynch, the new Attorney General, can't just change the underlying policy back to what it was in 2010 so it complies with the Inspector General statute. How in the world somebody can come up with a legal opinion of 66 pages is what I count, 67, and say that the law since 1978 is somehow preempted by these carve-out provisions, and all does not mean all, just defies any common sense whatsoever and any legal theory that I'm aware of. It's a responsibility of a judge or a lawyer rendering a legal opinion to try to reconcile and harmonize the law, not to say, well, this trumps it. We decided in 2010 that that we were going to trump or preempt this all means all provision in 1978. Well, I just find it very disturbing, but frankly, it continues a trend that we've seen under the previous Attorney General, where he's the first Attorney General that I'm aware of ever been held in contempt of Congress for failing to disclose information in the Fast and Furious investigation, which Mr. Horowitz knows an awful lot about, and upon which he's rendered at least one report. But it strikes me as, unfortunately, the Department of Justice has become so politicized that it essentially is ignoring the mandate of Congress. I don't know why we should have to pass another law saying we really meant it in 1978 when we said all. We really, really mean it this time. That's ridiculous. Well, I wish the Attorney General would take a close look at this. There have been Office of Legal Counsel opinions that have been withdrawn in the past that were obviously erroneous, and this one should be. I hope she'll take a look at it. I have a lot of respect for Attorney General Lynch. I think she has the capacity to change the way the Department of Justice has been operated, and I wish her luck. She'll certainly have my support. But I also want to just mention the fact that the President has continuously failed to appoint Inspector Generals in a timely fashion. For example, the Department of Veterans Affairs has needed an Inspector General for 582 days. Yet the President's not made an appointment, despite letters from Congress urging him to do so. The role that each of you play, the Inspector Generals play, is absolutely critical to the functioning of our democracy and for our capacity for self-government. If any agency is in need of an Inspector General, it's a scandal-ridden VA. But if the Department of Interior, which has needed a new IG since 2011, is any indicator, it will be another 1,714 days before President Obama gets around to making an appointment. That's 3 times longer than he has been in office. That's simply unacceptable. So, what concerns me as well is the fact that apparently, by one estimate, nearly 40% of formal OLC opinions are not publicly disclosed in any way. I wonder how many other OLC opinions there are that choose to reinterpret long-standing law in a way that restricts the public's access, restricts the Inspector General's access to be the watchdog that we intended the Inspector Generals to be. I'm very concerned about that, and I hope Senator Grassley, Chairman Grassley, will pursue that further. So the joint Department of Justice testimony states that the OLC memo was requested, quote, to assist the department in resolving the complex legal issues implicated by the interaction of 3 statutes discussed. However, by all accounts, prior to 2010, no one thought the issue was complicated at all. What happened in 2010 to make what no one had before identified as an issue so complex? Can you share any insight, Mr. Horowitz or Mr. Perkins, I'll open it up to all of you. If you have any insight, what happened in 2010 to change the existing law?
I was not the Inspector General at the time, but my understanding is that the memos and decisions from the legal counsel at the FBI followed several OIG reviews of the handling of national security letters, exigent letters, and other hard-hitting OIG reviews, because there was no other change in the law, no policy change, no regulatory change. The same law, Section 6A, said all then. It says the same thing today. Grand jury Title III credit information didn't change either. So there's certainly no legal issue that occurred in 2010.
Well, based on the reasoning of the OLC opinion, I'm not sure Congress is capable of passing anything more comprehensive than saying all. I don't know. Anybody have any words you would suggest that we would include in that statute that would clarify this, that all really does mean all? I noticed some people are chuckling. It is laughable. It is laughable. And it's really completely unacceptable. This is, unfortunately, part of the politicalization that we found under the previous Attorney General that I think has just been a complete embarrassment. Mr. Chairman, I would yield back.
Senator Klobuchar.